great to welcome you back as we're continuing this series that we're doing on the American Constitution. I'm calling it The Roots of the American Constitution because that's one of the principal focuses we've had, but of course we're also interested in the basic content of the Constitution and the ways in which it's been applied and, in my opinion, sometimes misapplied down through the years since its original inception. We're going to be coming this time to another detail that's part of the Fifth Amendment and then skipping ahead to the 14th Amendment. Obviously, I'm not trying to cover everything comprehensively. I'm trying to really focus in on those areas that have been something of a controversial point or an important area, areas where really we should be very well informed as citizens of this country, as Christian believers who want to do the right thing for our country as well. And so we're thinking in those terms as we're going along. So we're going to start, again, as I say, with a little detail that's connected to the Fifth Amendment. We didn't get to it last time, but it's important and needs a separate conversation, which we're going to take up right now. But before we get started, let's just have ask God's blessing on this time together. Our Father, we're grateful to you that you give us the opportunity to reflect on our own history, reflect on the great thinkers that went into the construction of this document that we call the Constitution. We pray that our reflection on these matters at this moment would be guided by your Spirit, and that you would, as a result of this time together, give us greater clarity and understanding of the role that we play. We give you thanks for it in Jesus' name. Amen. Well, we start off at this point with one more detail in the Fifth Amendment that's called the Property Clause, or sometimes called the Takings Clause. I think you know that the founders of the American Republic took for granted that there was such a thing as the principle of private property. They got that idea, of course, most immediately from John Locke, who was an heir of the Puritan tradition. The Puritans had universally taken for granted the idea of private property, and really every major branch of the Christian movement down through history has really had no quibble at that point. They've had certain little dissenters, you might say, kind of minority reports occasionally arguing for more of a communal approach, but by and large that has been a tiny minority, and by far the vast majority of people who've been in the Christian tradition, as well as many other traditions, have understood the idea of private property. We're not surprised at that because manifestly that's the biblical assumption and outlook. You think about the instruction, both Old and New Testaments, that we encounter, and again we find principles related to the assumption of private property. The eighth commandment of the Ten Commandments says, "Thou shalt not steal." Well, of course, stealing is an irrelevant idea if there's communal property. If nobody owns anything, or if the state owns everything, then the whole notion of stealing becomes a non sequitur. You think about the principle of giving throughout the Bible, both Old and New Testaments. Well, giving doesn't make much sense unless you've got something to give, which once again stands for the notion of private property. The Apostle Paul condemns stealing, and he says, "Let the one who stole steal no more, but rather let him labor, working with his hands, so that he may have something to give." And the idea of productive labor producing an acquisition of property that gives us the capacity to serve God by that means as well as others is certainly just shot through the Scripture. So at this point we're on safe ground biblically, and certainly the Reformers affirmed this, and the framers of the Constitution had no particular objection to it. They were agreed as well that these rights to property were part of a broader complex of rights that were inalienable. So when John Locke would say life, liberty, and property were part of that which had been entrusted to us by God himself, the founders of the American Republic didn't have any quibble with that whatsoever. They affirmed it. They took that for granted, and indeed used that very language repeatedly in their own writings about it. Experiments in history that have tried to repudiate the idea of private property have invariably and predictably wound up in a state of utter chaos and confusion, a malaise, of course, a loss of incentive. All of these are the negative effects of a denial of the idea of private property. So when we come to the Fifth Amendment, we find that among many of its other provisions is a provision related directly to the notion of private property, namely quote, "Nor shall private property be taken for public use without just compensation." So private property cannot be taken by the state unless there is a provision of just compensation. This, of course, says a couple of things. It says in some cases the government can take your property, you know. If they want to build a freeway and your house happens to be in the way, then the government can, through a transaction called eminent domain, take possession of your property, but the requirement is that there be just compensation. This is founded on a couple of principles. One, that the property must be taken for public use. That is to say, it has to be something that the government is saying it needs in order to provide services to the public. And of course, most importantly, there's a requirement that the government pay you fair market value. Can't lowball you, can't give you an amount that's way less than what would be the market value if you were to sell your property on the open market. This, of course, is an important point because sometimes there have been cases where there's been an attempt to try to buy the property at much less than its actual value. There's actually a provision that you have a right to a jury trial. If the court or if the state comes along and wants to take your property and offer you 10 cents on the dollar kind of thing, you can actually require that that case be tried in court and that a jury will eventually determine what the property is worth. So that's the basic principle. It has been challenged a few times. There's been some interesting cases along the way. One of the more recent ones that I might mention is called Dolan versus the city of Tigard. Dolan was the owner of a store. He had a hardware store there in the city of Tigard, which is in Oregon, and he wanted to expand his parking lot. And so he applied for a variance from the city, which would allow him to expand his parking lot. It would have been pro forma. You would think ordinarily this wouldn't have been any particular controversial issue. But what happened was the city said, okay, Mr. Dolan, we're happy to give you the variance that you're requesting, but we want you to give us in return a bike path that will go right through your property. So we want to do a kind of quid pro quo. You know, we're going to give you the variance you're requesting, but in exchange we want you to give us this bike path. There was no just compensation for that. It was just simply doing a favor, you might say, for Mr. Dolan by granting the variance, or maybe more importantly, withholding that favor if he didn't agree to the bike path. The difficulty was that the value of the land that was going to become part of the bike path greatly exceeded the value of the land that was connected to this expansion of the parking lot. One was worth a great deal more money than the other, and so there wasn't really what you'd call here a just compensation. There was rather kind of holding hostage a favor from the city in exchange for his agreement to this bike path. Well, Mr. Dolan wasn't very happy with that. He actually sued on that because of that, and the case eventually wound up before the Supreme Court, and the Supreme Court indeed ruled in favor of Mr. Dolan, saying that unless there is just compensation, this is a violation of the Takings Clause, and that therefore the city had to do more than just simply grant a variance. There is a situation that can arise occasionally that's called rough proportionality. If the value, for example, that Dolan had been asking for in terms of the expansion of his parking lot had been roughly proportional to the value of the bike path that was proposed to go through his property, then it would have been legitimate to simply do an exchange. It's called rough proportionality, and in that case the court will permit it. But again, it's not without compensation. It just happens that the amount being offered by the one is comparable to that which is being offered by the other. But ordinarily, just compensation translates into dollars, dollars that are based on what is the fair market value at the time, at the place. And so that's the basic rule connected to the Takings Clause. One of the least popular cases that has occurred, I would say in the last 100 years or so of the court's handling of the Takings Clause, was one called Kelo versus the City of New London. You may recall that. This is a 2005 case, and there was quite an uproar that really spread through the country as a result of this particular case. This was a challenge to the provision in the Fifth Amendment that the government was permitted to take land for public use. What happened in Kilo was that there was a developer in the city of New London. The developer wanted to buy a tract of land in downtown New London. He wanted to develop it, and of course it would become a source of very significantly increased tax revenue to the city if he were successful in doing so. And so he was buying property along this tract, which was owned by various property owners, but he ran into a problem because some of the property owners in that area didn't want to sell. They didn't want to sell for fair market value or even a great deal more than fair market value. And so the question was what to do. The developer wanted the property. The landowners weren't permitted or weren't willing to sell, and it appeared that he was going to be in an impasse there. Well, the developer appealed to the city of New London and said, hey, why don't you guys just take this property under the auspices of eminent domain, and then you can turn around and give it to me later. And of course, the city realized that that would be stepping a little bit outside the bounds of eminent domain, because now the property is not being taken for public use, but really being taken for private use. Nevertheless, the city was so enticed by the greatly increased tax revenue they would get as a result of the work of this developer that they actually agreed to do it. Well, as a result of that, the landowners who were negatively affected by such a decision sued, and once again the case made it all the way to the U.S. Supreme Court. And the court did a very odd thing at this point. It looked at the Fifth Amendment, noticed that the language says specifically public use, and then the court added a little additional phrase, public benefit. And so if the land is going to be used for public use or for public benefit, then eminent domain can apply. Well, you can imagine the uproar that spread across the country. There were demonstrations in many cities across the country. Protests were ranging far and wide because this fundamentally violates the principle of private property. It basically said that the state could take property from one private owner and give it to another private enterprise if the state wanted to do that and call it public benefit. I'm happy to report to you that across the country, many states have enacted at a statutory level prohibitions against this very thing. But the case itself, Kilo, still remains the standing Supreme Court opinion on the subject. I expect one of these days there's going to be a similar case that will come before the court to allow itself to, change that. But for the moment, this problem is being being dealt with at the state level. The principle of private property, I think you understand, goes right to the heart of a productive society. If people are denied the right to private property, they basically become slaves of the state. That's been the testimony of history again and again. This is not a modern thing. This was understood clearly by the founders, and that's why they wanted to protect it. If you have ever been the subject of a criminal action that involved somebody rummaging through your private property, you probably recall the feeling of having been personally violated. Something deep in our psyche says that in many ways our private property is an extension of our own person, and thus we have a sense of the sacredness of it. John Adams, the founding father, said, "The moment the idea is admitted into society that property is not as sacred as the law of God, and that there is not a force of law and public justice to protect it, anarchy and tyranny commence." John Adams said that at a time when some of the greatest examples of that very principle had not even yet happened. But the truth of it, I think, is acknowledged by any sensible person. And so we're happy that the Fifth Amendment includes that particular provision. Well, skipping ahead to the 14th Amendment, I'm bypassing, of course, some very interesting other elements, but this is, again, as I say, is an attempt to simply summarize some of the high points and some of the more controversial areas that have come up in connection with these amendments. And I'd like to take a look at this point at the 14th Amendment. You know that the 14th Amendment was enacted along with two others, the 13th and the 15th, after the Civil War. It represented an attempt to try to remedy some of the abuses that were quite conspicuous And this was the opportunity after the Civil War to try to provide some kind of correction to some of these earlier abuses that were related to slavery and so on. The 13th Amendment, of course, outlawed slavery. The 14th Amendment provided a set of protections in connection with people who had been slaves. That was its principal purpose, and so the content of it should best be understood in terms of its original intent, which had to do with correcting these kinds of challenges that were being faced by people who had been only recently liberated from their slave status. The idea, first of all, that I want to focus on is this notion of equal protection. Equal protection under the law. You know that the symbol of American jurisprudence is Lady Justice. And Lady Justice, of course, is blindfolded because the imagery there is supposed to say that no matter who is standing before her, whether it's a person of great importance, of wealth, of influence, and so on, or whether it's somebody that virtually has no influence at all, Lady Justice doesn't want to know and doesn't really care, because her job is simply to administer justice equally, and that's really the principle of equal protection under the law. If some people get special status, if because of their political bias, they're given all kinds of additional benefits that others with a different political outlook enjoy, then of course you have a deep violation of the principle of equal protection. And that is exactly what this principle here in the 14th Amendment was intended to address. Equal protection under the law really represents a cornerstone of Republican governance. Now, equal protection does not mean that it's impossible to make certain distinctions, and I think we all know that there are a variety of distinctions we make which are rational and necessary in an ordered society without violating the principle of equal protection. You think, for example, that in most places an 18-year-old can vote, but a 17-year-old cannot. Generally speaking, men have been subject to a mandatory military conscription. Women have not. MDs, of course, can write prescriptions. Chiropractors cannot. Girls, if they want to, can wrestle on a boys' wrestling team. The reverse is not true. Out-of-state students may arrive in a state to attend a state university. They may have to pay an elevated tuition as opposed to in-state students. All of these represent occasions when there's been a distinction that's been made, and yet none of them have been regarded as a violation of equal protection, because you see there's a rational explanation for each of them. Each of them is based on some reasonable understanding that at points distinctions need to be made, and that it's for the good of the society and the good of the individuals involved that we do so. The requirement, however, is that if we're going to make such distinctions, they can't just be whimsical. They can't be driven by political bias. They can't be arbitrary. As was stated trenchantly in Northwestern Mutual Life Insurance versus Wisconsin, quote, "The classification may not be arbitrary and must rest upon real differences. Subject to these qualifications, the state has a wide discretion." Well, of course, anytime the state has any discretion at all, you want to be careful. The state always has, at least at times, a bias to abuse the discretion that's given to it. And so there has to be some way of testing whether the state's action is actually consistent with rational principle. And to accomplish that, the court has actually developed what are called 3 levels of scrutiny. 3 levels at which attempts by the state to classify people, to distinguish them by various means, will be scrutinized by the court to see whether or not such distinctions actually add up and represent any kind of consistent application of the principle of equal protection. So the 3 levels of scrutiny are, first of all, strict scrutiny, followed by mid-level scrutiny, and then minimum scrutiny. All right, so those are the 3 levels. Strict scrutiny involves a situation where the state is held to a very high standard. In other words, its attempt to distinguish people, to separate them into classes, is going to be given a very close and careful examination by the court. Generally speaking, very few attempts at classifying people will fall under the heading of strict scrutiny. The most important example of this would be race. Sometimes creed has been incorporated. Beyond that, not too much. The idea of race discrimination is probably the one that is most legitimate, because that was precisely what drove the enactment of this provision at the time of the ratifying of the 14th Amendment. That was the primary purpose for the Equal Protection Clause, to make sure that people who had formerly been slaves were not going to be subjected to unequal treatment under the law by virtue of that former slave status. Mid-level scrutiny has generally only applied to a very small class of situations. This is where the claim to make a distinction by the state is going to be given some judicial oversight, but there's going to be more flexibility. As a general rule, this has been the standard that's been applied to gender discrimination. Minimal scrutiny applies where the justification for the state's attempt to distinguish will generally be allowed unless it is purely and evidently arbitrary. I will tell you that when cases where the state has made a distinction are subjected to minimal scrutiny, by and large, the state always wins. Not always, but for the most part, the state wins because, of course, at this point, minimal scrutiny would say that what the state is doing is, generally speaking, going to be permitted without a great deal of resistance by the court. The area of equal protection that's been by far the most litigious, the most complicated, the most difficult has to do with race, the first of those categories that I mentioned to you earlier. And at this point, we look at the history of the Supreme Court and we say that really at best, the way in which this rule has been applied has been a little bit spotty. We have some of the most embarrassing cases in the history of the Supreme Court which have been related to race. I think probably the most infamous of them, the one you've all heard of, would be the case of Dred Scott versus Sanford. Dred Scott. This was a 1856 case. It involved a slave at the time, of course this is before the Civil War, whose name was Dred Scott. Dred Scott was a slave to a man who was a physician in the U.S. Army whose name was Sanford. Dred Scott had a wife, he had 2 kids, they were also in a slave status. Now you may recall from your U.S. history, in 1820 a rule went into place called the Missouri Compromise. This was related to the Louisiana Purchase, and the Louisiana Purchase was going to be distinguished between the northern portion and the southern portion, and that was called the Missouri Compromise. The southern portion would permit slavery, whereas the northern portion would not. In fact, the northern portion actually outlawed slavery. So that was part of the ongoing compromise in the United States at that time. Well, part of the prohibition of the Missouri Compromise was that it was illegal to take someone who was in a slave status and carry him over to a free area. Now, there was no particular provision in the Missouri Compromise as what the impact of that would be, but nevertheless the rule was that it was simply illegal to do that. What took place was that Dr. Sanford, took his slave, Dred Scott, across the border into the free area of the Louisiana Purchase. Dred Scott was a pretty smart guy. He figured once he set foot into an area that was free, where slavery was illegal, that by the nature of the case should make him free, because in fact it was illegal to do the very thing that Sanford had done. And so on the basis of that, Dred Scott sued Sanford to establish his freedom. And that was the case that eventually wound up before the U.S. Supreme Court. Well, the U.S. Supreme Court looked at the situation and actually ruled on a preliminary matter against Dred Scott. Never looked at the merits of the case, never looked at how the law should apply if a slave were taken to a place where slavery was illegal. It never got to any of that because it basically ruled that Dred Scott did not have standing. In the law, standing means you have some vested interest in the case that gives rise to a legitimate reason for you to be able to bring a lawsuit. If I see a fight between 2 people and one guy punches the other and I have no part in it, then I have no standing. I can't sue on behalf of either one of those people because I have no reasonable participation in the situation. Standing is an idea that says before I can even be heard on the merits of the issue, I have to have some showing that I've got a dog in that fight, that I've somehow got some justification for being there. Well, in Dred Scott, the court ruled that Dred Scott did not have standing, you see. So it basically preempted the whole issue of the legality of what Sanford had done, because it said basically that Dred Scott was not a citizen of the United States, and therefore he did not have the legal right to bring a suit in the first place. It's a remarkable decision, a really tragic decision on the face of it, but it was the holding of the court at that time in 1856. Just to add insult to injury, the court also ruled that no slave or descendant of a slave could ever be a citizen of the United States. It was really one of the most remarkably horrific decisions we can possibly imagine. And in terms of embarrassing Supreme Court cases down through the years, Dred Scott has to be right at the top of the list. Well, it wasn't more than 10 years or so later, of course, that we have the Civil War is resolved. And of course, the North won, and following the Civil War, several amendments were attached to the amendments of the Constitution, including the 14th Amendment, which was essentially an attempt to overrule once and for all Dred Scott. And it provided, among other things, that any person who was born or naturalized in the United States was a citizen automatically. And so that, of course, was a way of saying every slave that had been a slave in the United States, born in the United States, was a citizen of the United States. And of course, that would suggest that all the rights and privileges appertaining thereto should connect to these people as well. Well, so far so good. That was certainly a move in the right direction. But nevertheless, as you know, in the succeeding years, in the South especially, were the so-called Jim Crow laws, which basically legalized all kinds of discriminatory behavior toward people who had been formerly slaves. That issue was eventually tested in a case called Plessy versus Ferguson. Plessy versus Ferguson involved a man who was actually only 1/8 black. He was by far mostly a white man, you know, but he sat in a whites-only car of a train. He was told to leave. He refused. He was ejected and then arrested. And on that basis, he filed suit, and that case wound up before the U.S. Supreme Court. This was in 1896. And the court once again ruled in a way that it thought was consistent with the 14th Amendment, announcing a policy that was called separate but equal. And that became the law of the land then for some years in the future. Now, you know and I know that when you hear the phrase separate but equal, what it means is that somebody always sits in the back of the bus, you know. Separate but equal certainly means separate, rarely means equal. And that became the practical reality in the United States then for some years to come. Another unfortunate case of the string of race-oriented cases was Karematsu versus the United States. This was a 1944 case. It was during the Second World War. Karematsu was an American citizen of Japanese extraction. He lived in a home, he had a job, he had a family, he was just another citizen of the United States, but there was a congressional act that said all people of Japanese extraction were to be put into internment camps. This was 1944. Karematsu, standing pat on his citizenship status, refused to leave. He pointed out that to take him and put him in an internment camp was going to represent a violation of the Equal Protection Clause, because in fact people of German extraction who were American citizens were not sent to internment camps, and we were at war with Germany. People of Italian extraction who were American citizens were not sent to internment camps. It was only the Japanese. And so he said, you know, where's equal protection when you need it? And that case made it to the Supreme Court. And the Supreme Court basically agreed with Karematsu in principle, saying that the classification that was being advanced here by the state was certainly a suspect classification, but using, I would say, language kind of along the lines of desperate times call for desperate measures. The court said nevertheless they were going to permit the application of the internment camp to Mr. Karematsu because we were at war, and that calls for extraordinary responses at times. So unfortunately, that was the outcome in that case. The one case that probably represents the high point and really a reversal of a great deal of the abuses that had taken place earlier, courtesy of the Supreme Court, is called Brown versus Board of Education. Brown versus Board of Education, as you probably know, involved a young black girl who wanted to go to a white school. It was a whites-only school. She sued, and of course, when the court eventually heard it, it announced a new policy, basically rejecting Plessy versus Ferguson and the rule of separate but equal, and put in place a different rule, which was called the rule of integration. And at that point, of course, everything changed in the United States. It was a good decision. It wasn't based on really good reasoning, I have to tell you that. So the outcome was good. The road that the court took to get there was at least a little bit dubious. The court could have reached the right decision simply by going back and looking at the 14th Amendment, looking at the meaning of the terms at the time, and applying rigidly the meaning of the 14th Amendment to the fact situation before them. They would certainly have reached the same conclusion. But what the court actually did was it spent quite a bit more time dealing, you might say, with the morality of segregation. It talked about the psychological impact that a person will sustain if they grow up in a segregated society. And it talked about the evils that flow from that. Now that's all true, you see. No objection to any of that reasoning. It's very important for us to understand all of those things. But the problem is when the court basically uses its moral conviction, its moral instincts, in place of a legal analysis, and uses its moral judgment, its conscience, as it were, to reach a certain conviction, then you've sort of opened the door to some difficult problems. Because in a sense, we've said to the court, okay, court, we're going to let you insert your conscience into this social problem and base your conclusion on your conscience rather than on the law. And if I can just put it in the vernacular, we've sort of given the court a license to kill at that point. It's okay, you know, when I happen to agree with the morality of the court, I can say, well, no harm, no foul. But what happens when sometime later a different court inserts its conscience into a matter that involves the way we live our lives, and the conscience of the court is very different? And basically I say, well, what the court is saying is you know, a conscientious outlook actually is quite offensive and really represents a great departure from what a good conscience should dictate. I've really already given up my ability to challenge it, you see, because I gave the court the license to insert its conscience way back in Brown versus Board of Education. It's ironic because, of course, Brown is a good case. It's a good outcome. I endorse it. I believe it was the right judgment. But the road that was taken there was somewhat problematic, and for that reason, I'm raising that little bit of a question. The other area under equal protection where there's been some interesting judicial involvement is the whole problem, or the whole policy, maybe I should say, of affirmative action. You know that affirmative action involves preferential treatment to those who have historically been victims of discrimination. It is, in a sense, a discriminatory policy that runs in the reverse direction. Almost immediately when affirmative action was implemented in various quarters, the objection was raised that you're fixing discrimination by implementing discrimination, and that certainly was a challenge that had some merit at the time and has ever since. The first major challenge to it on that basis was the case of the University of California versus Bakke. Mr. Bakke was an applicant to the University of California School of Medicine. Twice he was he was passed over, and people of inferior academic credentials were admitted, but they were admitted based strictly on race. It was a strict application of a quota system in which a certain number of minorities had to be admitted, and for that reason Bakke, of course, failed the test. Well, Bakke sued based on the fact that this was a violation of equal protection, that he was being discriminated against based on race, and in fact the court eventually agreed with Bakke, and he did gain admission and so on. But the court did leave a little bit of a less than firm rule at the point. The court allowed discrimination based on race under affirmative action policies as what it called a soft factor. So firm quotas, rigid quotas, were rejected, but the idea that it could be one of several factors was allowed, and that has been, from that time on, really the principle that's applied. So affirmative action hasn't been fully eliminated, but its application has been somewhat limited since that time. All right, well, the last area that I want to look at under the 14th Amendment for our presentation this time around has to do with abortion rights, which again was developed based on a certain reading of the 14th Amendment. The question is, does the 14th Amendment create a constitutional right to abortion? Of course, the case that basically established, in the opinion of the court at that time, 1973, was the case of Roe versus Wade. The case of Roe versus Wade focused on the word liberty. No one can be deprived of life, liberty, or property without due process. And then the court used the idea of substantive due process, which we've talked about before, to incorporate into the word liberty certain provisions of the Bill of Rights. The provisions of the Bill of Rights that were incorporated had to do with privacy. For example, a reasonable expectation of privacy under the Fourth Amendment, and various others were cited as creating this idea of privacy. That still didn't quite get the court there, and so then the court spoke of emanations and penumbras related to privacy, and on that basis, in a very thin piece of legal reasoning, it came to the conclusion that there was a constitutional right to an abortion, which I think you would have to say, I think even people who disagree with my position right now would have to say, would have been shocking, to say the least, to the Founding Fathers to hear that the Constitution, or the 14th Amendment in this case, would contemplate an actual constitutional right to an abortion, but that was the reasoning. The case of Roe versus Wade, I've read it several times. In fact, I used to assign it as reading in class I taught in political theory. And generally speaking, if you read it, you realize that a lot of the case is really quite good. It represents a rather expansive summary of the history of abortion and infanticide throughout the ancient world and down through history. It noted that a great deal of the ancient world took infanticide and abortion absolutely for granted. In spite of the Hippocratic Oath, which specifically repudiates the practice of abortion, the common practice of the ancient world was not only to do it, but to think very little of it. Human life at the time of birth was considered to have virtually no value. The parents had absolute rights to simply take the child, leave it outside, expose it to the wild, and that would be the end of that problem. And the court does do a pretty good job of summarizing that and making it at least part of the foundation for its reasoning. The court also acknowledges that the Christian movement, which began in the first century, it didn't take the Christian movement long to recognize the appalling abuse that is connected with this particular practice. And in fact, it's well documented that by the early 2nd century and thereafter, Christian people would go out into the highways and byways looking for such children that had been abandoned and left to the wild, and they would take them in and rear them in their own homes and give them a life that they never would have had otherwise. That continued to be a growing sort of view of things in the period until finally under Constantine, infanticide, abortion were both made illegal. The case of Roe versus Wade spent a lot of ink, looking at ancient practice, much more ink, I might add, than it spent looking at what was the view of the people that wrote the 14th Amendment in 1868. And so the court upheld this right of abortion based on liberty, a certain reading of, and really expansion, a rather dramatic expansion of the meaning of liberty, and it, at the same time, virtually gave no attention to the meaning of liberty that would have applied in 1868. Maybe even more distressing, it didn't look at a deeper question, which is very much a part of the 14th Amendment, namely the definition of a person. And really that's the critical question that was really simply almost ignored in the case of Roe versus Wade, is how do we define a person? Because if in fact we reach the conclusion that a person includes somebody who is an unborn child, then of course we have a different principle in the 14th Amendment that kicks in, because it says no person may be deprived of life, liberty, or property without due process. And in fact, this is precisely what's happening. We're denying a person the right to life without due process. So what would be the view of a person in 1868? Well, the first place to go is simply look at the language of the 14th Amendment. And if we do so, we read a very interesting short sentence here, which says the following: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now you have to say, looking at that on the face of it, it's not really defining what a person is. It is, however, defining what a citizen is. The purpose of it, of course, was to meet what had taken place, the abuse that had taken place in connection with Dred Scott, and declaring that if a person is born in the United States, that person would be a citizen. But the question is, when we hear the phrase all persons born or naturalized, is that statement of a person referring to someone who in fact would be a person before they were born, you see? And on the face of it, you would have to say that would be the plain sense of the reading. I'm not going to say it's explicit, but it's certainly powerfully implicit that would be the assumption. If I say a person is born, then the natural assumption would be that the person was a person before they were born. Something happened when they were born, but it wouldn't be saying that they became a person when they were born, or the phrase all persons born doesn't quite make a lot of grammatical sense, you know. If I were to say to you, for example, that all cars manufactured in Detroit are American cars, you might say, okay, fine. But then if I said all cars manufactured in London are not American cars, you would say, okay, fine, that's obvious. But what if I said to you, all cars manufactured in London are not cars? Well, wait a minute, that goes a little beyond the sense of the statement, doesn't it? I'm assuming it's a car. The question is, what is its class as a car? Is it American or is it not? By the same token, when I say all persons born are citizens, then you would say that the person is probably a person before they were born, but now their status has changed as to the question of citizenship. That would be the plain sense of it, at least. And that's probably the way it should have been construed when the 14th Amendment was considered at all. That this amendment was written to protect persons, not just citizens, and we know that from another provision of the 14th Amendment, which makes the following statement. Now I want you to notice here both the word citizen and the word person. They're both used, but they're used independently to refer to two different classes of human beings. So we have no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So if you're a citizen, you're entitled to the privileges and immunities that are connected with the Constitution, a term of art which is used in the Constitution. Then it continues and says, no state shall deprive any person of life, liberty, or property without due process of law. Manifestly, a person is something other than a citizen. Now, it may simply be someone here who is of a different citizenship who's visiting us, that could be. But the fact that it's also used earlier, all persons born, would suggest that it would also include people in terms of their prenatal status, that status that they had before they were born. Again, we have nor deny any person within its jurisdiction the equal protection of the laws. Well, my point is here, if we simply look at the plain language of the 14th Amendment, it would be very hard to construct an argument that's very credible in favor of the pro-choice view, at least as to the nature of a person and the rights that attach to that. But we can not simply cite the language of the 14th Amendment. We can also ask the very pertinent question, what was the definition of a person in 1868? When the 14th Amendment was enacted, because indeed to ask questions, what is the definition of terms that are used in a statutory or constitutional provision, is a legitimate inquiry that should be made. So when we ask the question, what do we learn? Well, it's not hard to find out. We know that, for example, in the late 1700s and early 1800s, a child was considered alive at quickening. That was a common view. Now, of course, medical science has helped clarify the situation some, but of course you know that at the time when a woman who was expecting a child felt that child move within her, that was generally viewed as a sign that the child had come alive. You know, that was the notion. We know more than that today, but the point is, at the time, quickening was the moment when this unborn child was considered to be a person and would acquire the rights that would be attached to personhood. In fact, so much so that in 1857, and this was admitted, by the way, expressly in Roe versus Wade, the destruction of a human life in abortion was called, quote, the destruction of human life. That's exactly the phrase that was used. Before 1868, 30 of the 37 states that constituted the Union at the time had significant bans or actually outlawed outright the practice of abortion. And Roe versus Wade frankly admits that. It admits there was no recognized liberty to abort an unborn child in 1868, that would have been an anomaly of extraordinary proportions if it had been presented to the framers of that amendment. The unborn child was considered to be a person for purposes of protecting life at that time. Well, what was the logic of Roe versus Wade to reach a different conclusion? Well, as I say, it was to import into the Liberty Clause a certain set of values and assumptions that probably would have been a big surprise to the framers of that amendment. And then the court relied on certain cases that were kind of a patchwork, actually 9 separate cases, none of which had to do with abortion, but had to do with ideas of privacy or an expectation of privacy, and so on, and used that, of course, to extend its logic to the idea of a constitutional right, an inherent constitutional right to abortion. In addition to that, the Supreme Court actually said, and when I've read Roe versus Wade, this has always been the line that jumped out at me almost more than anything else. The court acknowledged it did not know when life begins. It did not know when human life begins. It didn't know. It frankly acknowledged it. It sort of begged off saying, hey, theologians and philosophers have been debating this for years. Who are we, Supreme Court justices, to make a decision on that point? So the court actually announces it doesn't know when human life begins, but then it reaches a conclusion that says we can eliminate what may be human life under a constitutional right that we've announced here in connection with the 14th Amendment. I used to illustrate this when I taught this to high schoolers. I said, you know, let's imagine that I roll a big black box into the classroom today, and it's big enough, and I say, okay, everybody, there may be, we don't know, but there may be a human being in that box. And then I would offer $10 to anyone who would like to come up, take a gun, and shoot some holes through that box. And of course they would all laugh, well, they're not going to do that because there may be a human being in there. And I said, okay, hey, I'll offer you $100 or $1,000. How about $1 million? Nobody was willing to take me up on that offer because they all knew that if there was a human being inside that box, that the act of shooting bullets through that would be an astronomical injustice to that person. It would be a criminal act, and so on, and it would subject them to legal exposure that would greatly exceed any value they might receive by money that I offered to them. And so it was not a problem for them at all. And yet, you see, that's precisely what the court did here. It said, we don't know when human life begins, but we're going to nevertheless gratuitously allow that there's a constitutional right to an abortion, even in connection with this, which is basically an unknown, namely what is in that womb of that pregnant individual. So the court reached that conclusion. Basically, it wrote a statute. It's written very much in a statutory kind of framework. It imposed it on all the nation. Oddly enough, a great deal of Roe versus Wade could have been written by a pro-life person. Would have been no objection to it, but the conclusion reached was a shocking one, I would say, at best. Personally, I think I'm very happy that recently the court has overruled Roe versus Wade, kicked the issues back to the states. It hasn't made a ruling either way in terms of an affirmative a legal response. It simply said that we have 50 states, and 50 states are going to have to haggle this out politically, which is really a much more appropriate forum in which such a debate should take place. All right, well, that's going to do it for this time. Appreciate your attention to these matters. We're just looking at some of the more important elements that have been part of our constitutional history. I'll just say this, we have one more installment that we're going to make in this series. It's going to be 2 weeks out. If you're following this in real time, then next week I'm going to be out of town. I'm going to be indisposed, but 2 weeks out, we should be able to make the last installment in this series on the Constitution. And I sincerely hope that you'll be able to join us at that time. And until then, I pray God will bless you and that you'll continue to be able to gain benefits from this study of the Constitution. And until then, we'll see you next time.